Hello, everyone. My name is Nausica Palazzo. I'm an assistant professor at Nova School of Law in Lisbon, where I teach comparative family law and European law. I'm very thankful. Let me take a moment to thank the editors of Diritti Comparati for this appreciated invitation to present my book that was published 2 years ago, Legal Recognition of Non-Conjugal Families, New Frontiers in Family Law in the US, Canada, and Europe, published by Hart Publishing. So the question at the center of this book and actually my doctoral dissertation was, why are Western states taking the a specific kind of family, so the conjugal family, the family that resembles the traditional nuclear family as the benchmark to allocate legal benefits, right? So why is this happening? And most importantly, why this specific feature of conjugality? So the idea that families should have a sexual component to deserve legal recognition has such a gravitational pull, right? So my case study for the book to assess whether the law could expand its reach to recognize a larger set of family, this case study were committed unions of friends and relatives. So non-conjugal unions of friends and relatives, and particularly of two friends and relatives, because non-dyadic unions seem to pose even more complex challenges. So I focus on this specific case study to understand these ongoing attachments to conjugality in our legal systems. And I thought that non-conjugal unions of friends and relatives were an interesting case study because in many ways they, yes, challenged our understanding of family, but they also enjoyed a little bit more higher social acceptance compared to same-sex couples, as noted in scholarship, which ironically endured much more ideological resistance to the point that the legal recognition of friends and relatives could be much smoother, scholarship says. And then there is a clear interest on the part of the state in recognizing care and in promoting caring relationship. And there is a clear care component within relationships like those because friends, relatives, which are adults and which are committed and interdependent emotionally and economically, clearly are providing also that kind of support and care that is something valuable for the state. My analysis is, first of all, comparative in nature. I cover four jurisdictions: Canada, the United States, the framework of the European Convention of Human Rights, and the European Union. And I try to understand, especially looking at the case law produced by the copious litigation brought by same-sex couples, right, in the last few years, whether committed friends and relatives could also benefit from that case law, or whether there are obstacles in the contemporary constitutional doctrine that would prevent these friends and relatives from gaining legal recognition through courtroom litigation. So I look at these four jurisdictions to understand, first of all, how have non-traditional families framed their problem, their issue, whether one of equality, whether one of liberty. And then I try to look at how the states try to defend their policies or open up their policies to encompass a larger set of families to see whether these interests cut in favor or against non-conjugal unions of friends and relatives. Just to provide some examples, when states were brought to the before the judge, right, to explain why they were not including within their laws and regimes same-sex couples or de facto couples of to conjugal or not unmarried adults, right? Why they were restricting these laws and excluding these people, they had to provide reasons, right? So they, for instance, put forward the state interest in promoting the traditional family, the bare preservation of the special status of marriage, but also morals and tradition. And we saw how courts, in a comparative perspective, started to erode these kind of specific interest as something that could not support exclusion, not anymore, right? We cannot exclude people simply based on tradition, based on the fact that we didn't do we did that in the past, or the trickier interest in mitigating the risk of fraud. So for the instance, this idea that two friends and relatives could gain legal recognition because they want to fraud, to gain the system, right? And this is a tricky interest to the extent that I think it touches at the heart of some ingrained assumptions that we have as to what is family, right? Because it seems to point to a difficulty on the part of the state to see these friends and relatives as potentially family, right? So the idea that they would probably try to game the system has rather to do with our own understanding of family that's not that's still very much rooted in the traditional family. And then there is the interest in protecting the public purse, so the money of the state, which is oftentimes offered, especially in North America. So to conclude, there are several obstacles standing in the way of the legal recognition of this kind of families, and states have multiple interests in preserving a singular understanding of family, ranging from morals, there's no money, and so on and so forth. And the recognition of these families probably hits many raw nerves of contemporary societies as we witness the liberal turn, right? Especially in Europe, starting from 2014. So this idea that we should go back to the traditional family, which also makes me think that the research that I've conducted is very much relevant to the extent that we could not take for granted at all this kind of linear progression that seemed to point in a clear direction, which is the expansion of family law, right? The expansion of family law to encompass a larger set of family, which is now something that we can no longer take for granted as we witness in liberal actors and liberal ideals, in liberal norms taking center stage in Europe and beyond. Thank you very much for your